A dot check is a dishonored check returned unpaid by a bank because the account holder does not have enough money to cover the amount. As it might sound simple or common, hey, it is actually a crime and it is consequential. Hello and welcome to The Eagle from the stables of the Economic and Financial Crimes Commission, EFCC. On this program, we discuss economic and financial crimes and corruption, the effects and how we can all eradicate it. My name is Golden Omura.
Naira is 500 million naira.
Ihu na ihe naira na-eme ugbu a. Naira esighị ike. Achọrọ m ego m na-ego igwe dollar.
Die break na Nigeria. Ka ị na-achọ ego igwe dollar. Ọ bụ ya bụ na iso na ndị na-ebunye naira ibu arọ. Mee ya nne. Hey! Abịa gị na ndị otu gị unu esoro na-agba egwu na-azụ ya ọkpa na-ede ihe n'elu ya na-emekasị ego naira. Mee ya mkpọmkpọ ego.
Nwanne nwayọọ.
Agaghị m ewere ya nwayọọ ọbụla maka na ngalaba task force ehiwere na EFCC na-emegide ụdị ihe a unu na-eme imetọsị ego ime ihe ga-eme ka ego Naịjirịa ma ọ bụ akụnụba obodo anyị Naịjirịa ọ dịghị mma. Ejide gị ejide ị ga-eji eze gba ekwere o megori kebina.
An operative of the Economic and Financial Crimes Commission, EFCC, Kazim Yusuf, on Tuesday, November 18, 2025, told the High Court of the Federal Capital Territory, FCT, that the sum of 4.6 billion naira from the Office of the National Security Advisor, ONSA, meant for the supply of security equipment was diverted to sponsor pilgrimage to Mecca, the 2015 People's Democratic Party, PDP rallies, and presidential elections, among others. Yusuf stated this at the resumed hearing in the ongoing trial of a former Minister of State for Finance, Ambassador Bashir Yuguda, a former National Security Advisor, Colonel Mohammed Sambu Dasuki, retired, former Governor Atahiru Bafarawa of Sokoto, his son Sagir Atahiru, and a company, Dalhatu Investment Limited, owned by the former governor and his son, before Justice Yusuf Halilu, sitting in Maitama, Abuja. The defendants are being prosecuted by the EFCC on behalf of the federal government on an amended 25-count charge bordering on misappropriation, criminal breach of trust, and receiving stolen property. Amaka Ekeng reports.
Yusuf was led in evidence in chief by the prosecuting counsel, Rotimi Jacobs, SAN. Yusuf told the court that investigations revealed that while contracts awarded by ONSA for the purchase of security equipment were not executed, the 4.6 billion involved was diverted to other uses. He stated that investigation by the commission revealed that the contracts were for the supply of security equipment. Responses from the Office of the National Security Advisor also showed that the contracts were for security purposes. Further investigation, he stressed, also showed that the money, 4.6 billion naira, was not used for the purpose as the contracts were never executed but rather diverted to other uses. Testifying further, Yusuf stated that when he commenced the investigation and asked the fourth defendant, Sagir Bafarawa, how the money received was spent, Sagir brought a list of expenditures to the commission. Some of them include payments for pilgrimage to Mecca, organization of People's Democratic Party rallies, payments of monies to security agencies for monitoring elections, payments for the 2015 president election, and other political activities. Asked to read from the United Bank for Africa and Guarantee Trust Bank account statements tendered before the court, the witness informed the court that money was transferred to some beneficiaries. He mentioned some of the beneficiaries to include Sheikh Abdurrahman Al Sudais Foundation, which he said belonged to former Governor Bafarawa, its chairman. The foundation, he said, received a sum of 500 million. The prosecution witness too also mentioned the 2015 PDP gubernatorial candidate in Sokoto State, Abdallah Wali, who received the sum of 580 million naira for the election through a company. At the end of Yusuf's testimony, based on consensus, Justice Yusuf adjourned the case to 9 to 10 November for cross-examination of the prosecution witness too by the defense counsel.
Justice Raman Oshodi of the Special Offences Court sitting in Ikeja, Lagos, on Tuesday, November 18, 2025, convicted and sentenced the duo of Hamza Zakaria and Nuruddin Mohammed Ibrahim to 2 years and 2 months imprisonment for their role in a 8.56 billion naira fraud involving unauthorized access to a new generation bank's computer systems. Zakaria and Ibrahim were initially arraigned on May 2nd, 2025, alongside other defendants on a 4-count charge bordering on conspiracy, stealing, and unauthorized access to a computer system, contrary to Section 409 and 331 of the Criminal Law of Lagos State, 2011. Amata Ngbede has the details.
In one of the charges brought against the two convicts, it was alleged that there were some other persons at large. Sometime in January 2025 at Lagos, within the jurisdiction of the Honorable Court, conspired amongst yourselves to transfer and otherwise retain criminal proceeds from unauthorized access to a new generation bank's computer and servers. In another court, Hamza Zakaria and Nuruddin Mohammed Ibrahim and other persons at large were said to have some time in January 2025 at Lagos, within the jurisdiction of this Honorable Court, transferred and otherwise retained control of 24,890,000 paid into Exact Group Limited account domiciled with the bank, which formed part of the 8,586,090,500 naira stolen from other domiciled accounts within the bank through unauthorized access to their computer and server. They pleaded not guilty to the charges when they were read to them. However, on Friday, November 14, 2025, the defendants changed their plea to guilty, following the presentation of amended charges by prosecution. While reviewing the facts of the case, a prosecution witness was called who addressed the court on the charges preferred against the defendants and tendered several documents which were admitted as exhibits, prompting the court to convict and sentence them accordingly. The Economic and Financial Crimes Commission (EFCC) and the Nigerian Copyright Commission (NCC) have resolved to deepen their partnership against piracy and intellectual theft in a bid to make them unprofitable and protect the creative economy in the southeast. The resolution was made when the Enugu State Coordinator of NCC, Mr. Makfoy Akachukwu, paid a courtesy visit to the EFCC Enugu Zonal Director, Commander of the EFCC, CE Daniel Ise, in his office. While appreciating that the two agencies have collaborated over the years in many ways, Akachukwu said that pirated works are used to launder money and sometimes the money ends up in the hands of terrorists. He stated that his visit was in furtherance of the MOU and collaboration between the EFCC and the NCC, which has seen both organizations respectively provide logistics and institutional assistance. Akachukwu, while seeking for more support and strengthening of the already existing synergy, disclosed that pirated works are used to launder money as some people get involved in drug-related crimes, which they use the money to make pirated copies of major publishers, get them shipped to the country, thereby committing money laundering. Responding, Ise noted that piracy is a predicate offense to money laundering, and as such, the synergy between the two agencies must be deepened for the interests of the people of Southeast and the country at large. While highlighting the need for close collaboration between the two agencies, the Zonal Director noted that the collaboration is anchored on all that the EFCC does. My name is Amata Ngbede, reading for the Eagle News.
I actually came to pay the money for the recruitment consultancy you did for my company.
Beautiful.
I took 2 million.
Just hold on. I now collect dollars.
What?
Yes. I don't understand what's happening to Naira these days. So it's going to be 2 million times today's exchange rate.
Doctor, wait. Don't tell me you are one of those people who directly put pressure on the Naira and make it lose its value. You want to dollarize our economy and yet you pretend as if you don't know what is happening to the Naira. I've told you about how you abuse the Naira by spraying and stamping on it during your occasions. You deface and abuse the Naira as if it's not our national asset.
Chief, take it easy.
How? I will not take it easy. And neither will the Economic and Financial Crimes Commission Task Force on Currency Abuse and Forex Malpractice take it easy with you. They are coming for you. Desist from economic sabotage or you will face the wrath of the law.
According to the law, any person who issues a check knowing that there are no funds or that the funds are insufficient and could not fund his or her account within a period of 3 months, is liable. Let's now join Ayotomiwa Ayodele and our guests as they discuss the intricacies involved in dot check and what makes it a crime. Over to you, Ayotomiwa.
A check is a means of payments, an instrument of business transaction, an equivalent of cash transfer, but most importantly, a symbol of trust between two people. However, it has been found out that despite being a great asset in business transactions, checks could be misused as people deliberately issue it to evade personal or corporate responsibilities. This practice is called issuance of dot check, which simply is a check that is non-existent, considered worthless, or cannot be cashed because of insufficient funds or restrictions placed on it. Today, on this segment, I have Assistant Commander of the EFCC, Samuel Chime, of the Commission's Legal and Prosecution Department, to talk about this topic. Welcome.
Thank you.
What can we refer to as a check to begin with?
A check is an instrument which the drawer of the check is conveying an instruction to the bank to pay the bearer of the check the specified amount on the check upon presentation at the bank. So it basically means it's in the form of money which you are telling the bank to pay the bearer the said amount in the check. There are two ways to define a dot check. It's either it is dod and there's criminal liability with it being dod, or it is dod as a result of, not because of there's a criminal liability, but basically a dot check is a check which could not pass for clearing, which the bearer cannot be paid by the bank.
So how then can we say a check is dod, and what are the intricacies involved?
A check is dod. There are two ways to define a dot check. It's either it is dod and there's criminal liability with it being dod, or it is dod as a result of, not because of there's a criminal liability, but basically a dot check is a check which could not pass for clearing, which the bearer cannot be paid by the bank. So with respect to your question in terms of dot check, I know you are going towards the area of the criminal liability of a dot check. Okay, a dot check is a check which there's no insufficient money in the account to justify or to satisfy the amount of money specified in the check. But there are several factors that can also determine a dot check. First of all, there must be an enforceable contract between the drawer and the bearer. Then secondly, it must be presented within 3 months as specified by the Dot Check Act. And then thirdly, there must be insufficient amount of money in the account. Now, if all these parameters are met, then you can say the check is dod.
How rampant is this criminal act?
It's rampant in Nigeria, first of all. I think because of the economic situation, but basically in land transactions is rampant. In land transactions is rampant. In loan transactions is rampant. In land transaction because people buy land in anticipation that they will get the money, let's say in the next 3 months to pay for the land, or they don't have the complete money. They now issue checks in anticipation that within the next 3 months they will have the money to pay for the land. Also in loan transactions, when people borrow money, they also issue checks because somebody borrowing does not actually have the money. So he's issuing checks that in the next few months, when he's paid salary or when his business makes money, he'll be able to pay.
What makes issuance of a dot check a criminal act?
We have the Dishonor Checks Offences Act, is only the act regulating the issuance of check. And is the laws of the Federation of Nigeria enacted by the National Assembly. It's an act enacted by the National Assembly, so it regulates the issuance of checks. So the act provides that if you obtain credit or there's delivery or supply of goods through the means of a check, which upon presentation within 3 months, there's no sufficient amount of money in the account, and it must be made for a particular obligation. There must be a contract, an obligation between the drawer and the bearer. And then, if there's no money in the account, then it's a dot check.
What if I'm expecting some funds in my account and I had issued a check ahead of the payment?
No, it is not per se, especially if you are expecting funds in your account. If you're expecting funds in your account, you can actually issue a post-dated check. That's why it's allowed to issue a post-dated check. But the Act provides or requires that you should have that amount of money on the date specified on the check or within 3 months of the issuance. So if you issue a check for 15th November, within the next 3 months after the date on the check, you should have that amount of money to satisfy or to pay for that particular obligation. Yes, there are several intricacies that involve the issuance of check. But before I delve into it, it's important for me to read the specific provisions of the Act. Section 1 of the Dot Check Act says that any person who obtains or induces the delivery of anything capable of being stolen, either to himself or to any other person, or obtain credits for himself by means of a check when presented for payment not later than 3 months after the issuance of the check and is disordered, has committed an offense. Now, if you look at Section 1A of the Act that says you obtain or induce the delivery of anything capable of being stolen. Now, it's important to note that, first of all, the payment has to be made for a tangible or intangible goods, but not for anything capable of not being stolen. Now, it is the position of the law that land is not what is capable of being stolen. So in that case, if you issue check for payment of land and the check bounces, you cannot be held liable. It's important to note that there's a way to bypass that, which means that if you are selling your land, you should be able to give out documents like the CFO. So if somebody gives you a check and you've issued your CFO is tangible, is a tangible property. So if the check bounces, then it becomes an offense because the person has obtained the CFO via the issuance of a dot check. Now, secondly, Section 1B of the Act says also that it is also an offense to obtain credit by issuance of a dot check. Now, credit in this sense means forbearance. Let me give you an example. If you go to a store to buy a TV and the TV has not been delivered to you and you issue a check and in the next 3 months the check bounces, you cannot come to court to say the TV has not been delivered to you. There's a forbearance, which is a consideration by the shop or the seller of the goods not to sell those goods to another person. So what Section 1B is talking about is about obtaining credit. So you have obtained credit from the person, even though he has not delivered goods to you. So in that case, you have also committed the offense if he presents that check and it bounces, despite the fact that he's still retaining the goods. So in these are the intricacies that comes with issuance of dot check. It's also important to also note that this type of offense, we have issues where the drawer of the check signs the wrong signature, and in that case, the case is no longer issuance of dot check. It has nothing to do with forgery. So we have cases in EFCC where we invite the suspect and the suspect denies signing the signatures, and the complainant also is expecting us to still prosecute the person on issuance of dot check. It's no longer an issuance of dot check, but forgery. So we need to investigate whether he's actually the one that signed the signature or not.
You said something about some acts, and that makes it a criminal act. What act and what provision of the law criminalizes this act?
Okay, we have the Dishonor Checks Offences Act. Is only the act regulating the issuance of check, and is the laws of the Federation of Nigeria enacted by the National Assembly. It's an act enacted by the National Assembly, so it regulates the issuance of checks. So the act provides that if you obtain credit or there's delivery or supply of goods through the means of a check, which upon presentation within 3 months, there's no sufficient amount of money in the account, and it must be made for a particular obligation. There must be a contract, an obligation between the drawer and the bearer. And then If there's no money in the account, then it's a dot check.
Is this restricted to a level or certain category of people, or does it cut across board?
Yes, it cuts across board. Anybody can commit the offense of issuance of dot check. It's not restricted to any category of persons.
So what is the EFCC doing in tackling issuance of dot checks?
Okay, based on the functions of EFCC as specified in Section 6 of the EFCC Act, EFCC investigates the issuance of dot checks, being a criminal offense that affects the economy. Now, the first thing we do is we receive petitions. The EFCC investigates the offense by receiving complaints from the complainants. We also interview the complainants to determine whether there is a transaction, an enforceable contract. It's very important to note that for issuance of dot check to arise, there must be an enforceable contract. So if the contract is illegal, it's not enforceable, and you can also pay. You cannot also pay through check. So when we determine that there's an enforceable contract between the drawer and the bearer, or the complainant and the suspect, then we also write to bank to verify whether the particular check or checks are valid, and whether they were presented within 3 months, and whether there was sufficient amount of money in the accounts. Now, EFCC also plays a role by disseminating information through public affairs departments and through other modes of jingles or the EFCC Connect to inform the public that it's a crime to issue check, and the EFCC will actually prosecute you and investigate the matter.
As we wrap up the program, this segment, what exactly is your final words on issuing dot check?
It's important to also note that one of the intricacies that we see in investigation here that has to do with dot check is that people come to state that, when I say people, the suspects in trying to make a defense for issuance of dot check always posit that the checks were issued out of duress, or that the checks are collateral. And it's important to educate the public that when it has to do with duress, it's for the suspect to prove to EFCC or to the law enforcement agency that the check was issued out of duress. But any check issued based on duress is unenforceable, despite the fact that there's an enforceable contract. It's important to note that the duress may arise after the supply of the goods, but before the issuance of the check. So if in the purpose or in the period of issuance on the check, you obtain that particular check through duress, it's unenforceable if there's proof to EFCC. Then another defense, which we normally see, is that the suspect always also claims that the checks are collateral. And that's been held by the courts that checks are not collateral. Checks are cash payments. They're in lieu of cash. It's a representation via an instrument which you are saying, this is money. So it's in the form of money. So it's never a collateral for you to say, I gave it out as a collateral, that when I have money, I will pay you. So upon issuance, it becomes money, and it is in trust. So therefore, it has been criminalized by the Dishonest Checks Offences Act. Then also, it's important to also note that there are several unenforceable agreements or unenforceable discussions that can also attract punishment, or cannot also be termed dot check, like checks that are issued by family members as a gift, and if you present those checks and they bounce, the offense is not criminalized, unenforceable. Then we also have illegal contracts, where you issue checks as a result of a fraudulent activity between you and another party, and that other party gives you check. Then those checks are unenforceable if they bounce. You can't come to EFCC to enforce an illicit transaction. So these are the intricacies we see, and it's important the general public notes that in trying to bring up their petition to EFCC.
All right, thank you so much, Assistant Commander of the EFCC, Samuel Chime, for coming on the program today. We appreciate your time.
I believe you've heard it from Ayo Tomiwa and our guest on how to protect yourself from committing the offense of dot check issuance. Issuance of dot check is a crime with strong consequences. Remember, it's better to be on the side of the law than to be against it. Don't forget to keep the conversation going through our email info@efcc.gov.ng. If you want to speak to our officers, you can call 080-933-22644. Do follow us on all our social media handles, Instagram, Facebook, and X @official EFCC for all matters relating to economic and financial crimes and corruption. My name is Golden Onra. Thank you and enjoy the rest of your day.